In this presentation, I'm going to take you through the 2021 September examination paper for the subject Business Law as examined by the Zambia Institute of Marketing. My name is Savoy. I am a tutor, and I invite you to subscribe to my YouTube channel, Captain 37. My YouTube channel is called Captain 37. The 37 is a number, so it's Captain 37. Please do subscribe. And my Facebook page is Marketing Study in Zambia. Let's proceed and deal with question number 1. I encourage you to have the paper itself for you to appreciate the actual case as it was given. In this particular presentation, I have only presented, displaying to you only what the actual requirement was. And so a scenario was given. I encourage you to go through that particular scenario. And then students were required as follows. As an expert in the law of contract and tort, how would you advise the various parties on their liabilities that have arisen as a result of the inconclusive transaction and the unfortunate accident? So a scenario is given where Moses makes an offer to Jacob to sell his Mercedes-Benz. Moses makes an offer to Jacob to sell his Mercedes-Benz for 80,000 kwacha. Jacob agrees. After Jacob agrees, Jacob takes the car on a test drive. In the process of driving the particular vehicle, he fails to slow down. And as a result of him failing to slow down, he hits into a hump. And as a result of hitting into the hump, the oil pump to the motor vehicle gets damaged. Not only that, but he also hits a cyclist who suffers injuries. What then happens later on is that Jacob receives 2 bills. One of the bills is from Levi Mwanawasa Hospital, and the other bill is from Pilatus Garage. Moses requests Jacob to pay the 80,000 kwacha. Remember that Moses is the one that made an offer. He requests Jacob to pay the 80,000 kwacha and take the car as it is with the damaged pump. Jacob, however, refuses. He says, "No, I am not going to pay for it because it was an accident. I had no control over the accident. Moreover, there was no contract." That was the situation. So now, given that particular scenario, you as a student, you are an expert in the law of contract and tort. How would you advise the various parties on their liabilities that have arisen as a result of the inconclusive transaction and the unfortunate accident? How students could have approached this particular question is from 2 angles. Actually, from 3 angles. I will explain the third one. The first angle is from the angle of the law of contract. The second angle is the angle of the law of tort. Remember that I say there's a third one. I will explain the third one as I explain these particular 2. So let's analyze the situation. Was there a contract between Moses and Jacob? Was there a contract between Moses and Jacob? Remember that for there to be a contract, there has to be 4 elements. All these elements must be present for there to be a contract. There has to be an offer. There has to be acceptance. There has to be consideration. And there has to be capacity. I would like to add that as you study the law of contract, remember that under offer, you need to look at the following. Number 1, what an offer is. Number 2, how an offer terminates. And number 3, the difference between an offer and an invitation to treat. I mentioned those 3 for you to be able to take into consideration as you study. They don't exactly apply in this particular case, but I am mentioning them for you to know what to cover. And so the question is, was there an offer? Was there an offer? Let's look at this particular line of the case. Number 1, that Moses makes an offer. So it is clear. We have been told in the case that Moses made an offer. So yes, there was an offer. The second element that must be present for there to be a contract is acceptance. When you are studying the law of contract and covering the topic of acceptance, what you need to remember or what you need to know are the things that must be done. What are the legal requirements for acceptance to be valid? One of them is that acceptance must be communicated. And this is where, for example, you would learn about the postal rule as you study and as you cover the topic of law of contract and as you cover the topic of acceptance. You need to remember or take note of the postal rule. Very, very important. Was there acceptance in this case? Yes, there was acceptance in this case. We have already been told that Jacob did accept that he was going to buy that particular Mercedes-Benz at 80,000 kwacha. What is the 80,000 kwacha in this particular case? The 80,000 kwacha is what is known as consideration. Consideration is that which one party gains and that which another party loses. So consideration, as you study the law of contract, you need to be mindful of the characteristics or the requirements of consideration. For example, that consideration has to be adequate. Number 2, that consideration should not be in the past. Number 3, that consideration must be legal. And number 4, that consideration must come from the promiser, amongst others. What's important to note in this particular case is that Jacob accepts to buy the particular vehicle but has not yet paid. Does that then qualify as consideration? Yes, it is known as executory consideration. It's like, for example, when you start work. You start work on the 1st of November, for example, and your payment is going to be on the 30th of November. That payment is yet to come. It is executory. In this particular case, executory consideration is what qualifies. The third element, the fourth element that must be present and which we assume was present is that there is capacity, meaning one has the ability to engage in a contract. The three types of persons who are excluded, who lack capacity to engage in a contract are: number 1, a minor, meaning someone who's 16 years and below; number 2, someone who is drunk; and number 3, someone who is insane, someone who is mad. On the exam, they could ask you which groups of people are or which groups of people lack capacity. It is those 3. So in this particular case, we assume that capacity was there for him to drive. It means he has a driver's license and therefore he is over and above the age of 16. Having taken into consideration the fact that indeed there was offer, acceptance, consideration, and capacity, it means that there was a contract. So Jacob cannot then now claim to say there was no contract, because the elements that must be present for there to be a contract were satisfied. There was an offer, there was acceptance, there was consideration, and there was capacity. Students needed to make this point very clear in answering this particular question, that there was a contract. And now, if there was a contract, who is responsible for the oil pump damage? Who is going to pay for that particular bill? Remember that Jacob received 2 bills. One of the bills was from Levi Mwanawasa Hospital, and the other bill was from Pilatus Engineering. Who is going to pay for that particular bill? At this particular point, I need to remind you that I did mention that there are 3 areas of law you need to consider in this particular question. The first one is the law of contract. The second one is the law of tort. The third one is you need to apply the Sale of Goods Act. Sale of goods is one of the key important areas of law that you need to understand as you study for this particular exam in the subject business law as examined by the Zambia Institute of Marketing. And of particular interest under the sale of goods is 2 things. Number 1, what is known as possession, and number 2, what is known as ownership. you need to appreciate and understand the difference between ownership and possession. Ownership and possession are very important when considered in the light of the Sale of Goods Act, and also they are very important when you look at them as you study, for example, hire purchase. So what happens is that someone may have ownership. When someone has ownership, it means that they are the one who own. They are the one in whose name that particular property is in. In this particular case, ownership may not yet have passed or may have been passed. We have not been told whether ownership passed, but most likely ownership did not yet pass. What does that mean? It means that the documents that talk about ownership of the particular vehicle are still in the name of Moses. In which particular case then, if ownership has passed, meaning if ownership passed from Moses to Jacob, then Jacob would be responsible for the bill for the fixing of the oil pump. If, however, ownership did not pass, it means that Moses is responsible for the bill that has to be paid to Pilatus' garage. And so this is how students needed to address this particular question. They needed to cover this particular question from the law of contract, and they needed to cover it also from the law of tort. Along the way, a student would have to come in and explain how the sale of goods would apply when addressing who was going to be responsible, who had ownership, and who was in possession. I have not gotten into the actual details of that because that's a different lesson for a different day. My Facebook page is Marketing Study in Zambia. I invite you to like the particular page, and please do subscribe to my YouTube channel, Captain 37. My name is Savoy. We are now going to look at this particular case from the law of tort. We have looked at it from the angle of the law of contract. We now need to look at it from the law of tort. The scenario remains as it is. The question is, was there a tort? Who is responsible for the medical bills that have come from Levi Mwanawasa? Who is responsible? When it comes to the law of tort, the following three elements must be present for there to be a tort. There has to be a duty of care, there has to be breach of the duty of care, and as a result of breach of the duty of care, there has to be injury or harm that another person has suffered. In this particular case, was there a duty of care? Yes, there was, because as a driver, Jacob is responsible for his actions or his inactions as a road user. There are many other different types of road users, and therefore it is expected that Jacob must exercise duty of care. Did he do that? No, and that is why there was breach, meaning the breach is as a result of him doing that which was not expected or that which is not expected to happen. And what happened is that he failed to slow down. In the process of failing to slow down, he hits a cyclist. And as a result of hitting that particular cyclist, there is harm and there is injury. These three elements have been satisfied. There was duty of care, there was breach, and there was injury. If at any time as you analyze a case, any one of these is missing, it means that there is no tort. In this particular case, there is tortious liability because all the three elements, duty of care, breach, and injury, are present and are satisfied. Because that is the case, Jacob is liable, and therefore Jacob is the one who is supposed to pay the bills that have come from Levi Patrick Mwanawasa Hospital. I'm not sure if it's called Levi Patrick Mwanawasa Hospital, but going by the case, let's just call it what is presented in the case, Levi Mwanawasa. So this is how students had to answer question 1. I will proceed and show you how students needed to answer other questions. If you need further studies and further resources, I have a number of them on the YouTube channel Captain 37 and also on the Facebook page Marketing Study in Zambia. My name is Savoy, and feel free to get in touch with me in case you may need help with your studies. I wish you all the best. Goodbye.